Welcome to Austin, everybody. My name is Arthur Gallwitzer. I am the president of the Austin chapter, and I just want to welcome everyone to the 5th annual Texas Conference. I briefly want to say a couple words of thanks to Lisa Izell and Sarah Landine from the Federalist Society in Washington, D.C. As folks may or may not know, these events could not happen without the hard work of Lisa and Sarah, so thank you very much. We have what I hope is a terrific and timely program today. We are honored to have Senator Cruz as our keynote speaker. So on behalf of the chapter and all the Austin members, thank you for coming. And now I will transition to introducing our first speaker, and that is Chief Justice Nathan Hecht of the Texas Supreme Court. As people may know, he has served on the court since 1988. I understand that means he's been elected 6 times. That is phenomenal to me. I can't imagine putting up with 6 elections. He is the longest serving member of the court in Texas history. He most recently was reelected in 2014. He is also the senior Texas appellate court judge. Throughout his service on the court, he has overseen revisions to the Texas rules. I understand he's been appointed at one point by the Chief Justice of the Supreme Court of the United States to serve on a federal rules advisory committee. He has worked on projects to ensure that Texans of all means have access to justice. He was first appointed to the district court in Texas in 1981, the Court of Appeals in 86. Has a bachelor's degree from Yale in philosophy. He has a law degree, cum laude, from SMU. The honors go on and on here. He is, let's see here, served as a clerk to Judge Roger Robb on the D.C. Circuit Court of Appeals. So I guess with all that, thank you very much for joining us. And if you want to kick us off, we appreciate you being here.
Thank you. Well, thanks very much. Sorry you had to get dressed up on Saturday morning when it's only going to be a little over 100 today. But that's Texas in September. I'm just going to say a word this morning about state constitutionalism, prompted by my good friend Jeff Sutton's book on 51 Imperfect Solutions, States and the Making of American Constitutional Law. And maybe end on a sort of cautionary note. First of all, the federal republic that the United States has is truly amazing, and sometimes we forget about that. The Federalist Society certainly shouldn't, but it routinely happens at the Supreme Court of Texas that when we have judges and lawyers come from out of the country, they want to know, how in the world does this work? How can you possibly have courts with these overlapping jurisdictions deciding constitutional issues and issues of each sovereign's laws? How does that even work? When I explain to them that a justice of the peace in Texas can interpret the First Amendment to the U.S. Constitution, they're like, how can that be? And so it really is a phenomenal thing. And I think Judge Sutton makes a good point in saying that we should remember that the different solutions that states have found to particular problems are important in considering how we have resolved some of those issues and determined some of those rights under the national Constitution. But let me just say a word about that. First of all, of course, the constitutions are very different. I'm a little embarrassed to tell you that Texas has only the second longest constitution in the United States, weighing in at 87,000 words. Arkansas has 307, or Alabama has 376,000 words in their constitution. Of course, the U.S. Constitution only has 7,600, 7,591. So Alabama is 50 times longer than the United States Constitution and 4 times as long as ours. So we're going to have to get behind some constitutional amendments to try to catch up with Alabama. And many times, state constitutions have very unique provisions. Just mention one in the Texas Constitution, Article 16, Section 50. It prescribes how you perfect and enforce a home equity lien on homestead property. And you think, and it takes several pages. I didn't count the words, but it's like 3,000 words the last time. I think that's what I remember. But you think, why would they put that in the Texas Constitution? That's the things statutes are for. And the answer, of course, if you remember, is that Texas has a debtor-friendly history, that we've always been very slow to enforce obligations against people. Not that we don't do that, but Texas is just thought of as a debtor-friendly state. And I think we were the last state in the United States to allow home equity loans. And Senator Graham was reluctant. He was unsure about it too. And so the deal was, okay, we're going to let this happen, but we don't trust the legislature to come in a year from now or 5 years from now and relax all of these requirements that we're going to impose on home equity loans. So we're going to put it in the Constitution. So now there's no way they can do that without going to the people and getting a constitutional amendment. So it's a very long and detailed provision and very different from any provision in the United States Constitution, but not atypical of some provisions in other state constitutions. So one of Judge Sutton's arguments is that we shouldn't cede, state courts shouldn't cede interpretation of constitutions to federal courts. And of course that's true. The state courts should do their own job at enforcing not only the U.S. Constitution, but their state constitution. He gives an example of the effect on education, and particularly in Texas, uses Texas as an example. And back in the early 70s, the U.S. Supreme Court decided in a case that came out of Texas, Rodriguez, that there's no 14th Amendment right to education. So fast forward almost 20 years, and there is an action in Texas to complain about the way public schools are financed in Texas, but it's not under the Texas Bill of Rights or the United States 14th Amendment, because Rodriguez had pretty much foreclosed that, but it's under Article 7, Section 1 of the Texas Constitution, which is a very detailed provision that says how public schools should be financed, how they should be structured in Texas. And it has 3 standards in it: a general diffusion of knowledge, suitable provision, and an efficient system. And the first complaint back in 1989 was that the system that we have, that Texas has, is not efficient. And that's a manageable standard we held in the first Edgewood case. That's something that courts can identify and define and set standards for. And so that's how the case came out. A unanimous court said that the public school finance system back then was not efficient. Judge Sutton says that having the state constitutional provision sort of made it possible for people who were seeking greater rights in education to secure them apart from the 14th Amendment, and that's of course true, but it's only true because we had that provision in the Texas Constitution, not because we took another view of equal protection under the Texas Constitution. So while it's certainly true that state courts should interpret their own Constitution, just as they interpret the U.S. Constitution, part of the publicity surrounding Judge Sutton's book is that this would enable rights to be expanded. And I just want to say three things about that. First is it would allow rights to be expanded if, and this is a very important if, the usual interpretation framework that courts apply to constitutions would allow that result. Not just because judges thought on a particular day, oh, well, it would be better for the state if education were a fundamental right under the state constitution. In interpreting constitutions, of course, the Texas court, like most courts, would start by looking at the text, and the text is always important. But if you're dealing with Article 16, Section 1, and how to do equity loans, then the text is pretty important because they went through it in a pretty detailed way, and like many statutes, every word makes a difference. But when you're dealing with things like bills of rights and more general provisions, then the text is not often a final word on how the provision should be interpreted. So it's well settled in Texas that you look at historical context, collective intent, if that can be ascertained, of the framers and the people who adopted it, our prior judicial decisions, interpretations of analogous constitutional provisions by other jurisdictions, and then constitutional theory, which is a pretty vague concept, but nevertheless one that has developed over the years and can be used in trying to interpret provisions. And so that's what we did in Edgewood, was we went back to the 19th century when that provision was adopted. We looked through the legislative debates, the Constitutional Convention debates. We looked at famously at the Galveston newspaper, which had run an editorial on the Constitution and had talked about that provision, and tried to ascertain from that very careful analysis how that provision should be interpreted. And of course we did that because that's the way you should interpret constitutions, but we also did it because that's the only way the decision can have legitimacy. And so I've told people since then, the same issue has come up in other states around the country. And sometimes the legislature and the executive have been very reactive to the judicial decision, telling them that the school finance system was not up to snuff, constitutional snuff. So to be sure that the other branches particularly, but also the public, understand that the decision is not just what the 9 judges on our court think, but what the Constitution actually says, then it's very careful to go through this analysis. And some of the reviews of Judge Sutton's book have suggested, oh no, this is the rights can be expanded just because this justice or that justice thinks that they should be. And as much controversy as the U.S. Supreme Court decisions in those areas generate, you can imagine if you had 51 state courts doing that, there would be a great deal of controversy. So it's very important. First thing I wanted to say is that The caveat be, sure, state constitutions are important, and the state courts should look to them for guidance, but they should look the way that we always look to interpret the law, and not just because we think that this is the right way to go. The second thing is that Judge Sutton makes a very valid point that there should be some dialogue among the jurisdictions about constitutional provisions and the rights that they either create or limit. And our court, 25 years ago, rejected that argument in two cases, Davenport against Garcia and Ex parte Tucci, where we said in both cases, Texas first. And of course, I believe that with all my heart, but I'm not sure it's a good principle for interpreting the Constitution. But we did say in both cases that courts should, whatever the argument is made, whatever the parties have chosen to argue, courts should look first to state constitutional principles, and only if they can't find the answer there, then should they consult federal decisions or constitutions in other states. And one of the great contributions Judge Sutton makes is that he goes through the history of these provisions and shows how they interrelate, how the U.S. Constitution was drawn from other state constitutions that were already in existence, and then how states that came along later, like Texas, drew from all those backgrounds in adopting some of our provisions. So I didn't think the court was serious in Davenport and Tucci, and I wrote that at the time. And it turns out they weren't, or at least the court wasn't. And I'll just read this two sentences. To assume automatically that the state constitutional provision must be more protective than its federal counterpart illegitimizes any effort to determine state constitutional standards. And the second sentence, if the Texas Constitution is more protective of a particular type of speech, it must be because of the text, history, and purpose of the provision. So while it is important to consider our own text, our own provisions, it is also important to read them in context in which they were adopted, which was in light of other states' views of what these rights should be. And that only makes sense because many of these things were shared ideas at the time, even throughout the 19th century. There weren't so many differences that you can look at them completely differently. As distinct from the, from the public education provision in the Texas Constitution, which was a product of the age in which it was adopted. People felt very strongly about public education. Many Texans were against it. They thought it was a way for the government to control how children are educated. That we were just coming out of Reconstruction, and we felt like we didn't want this for, we were going to make sure that didn't happen again. And so there was a lot of feeling that there shouldn't be even a local government in charge of educating children. Then there were other people who felt very strongly the opposite, that there was no way to get it done if the government didn't participate. So all of that was a relevant history in applying the Texas provision, and that's what we look to. So it's important in applying state constitutions that we use the method that we ordinarily use, the interpretive framework, and not make it just a matter of judicial personalities, as Justice Gorsuch spoke so powerfully to last week when he was here. Secondly, we should look at each other's documents and not just our own, to see how common provisions have been interpreted elsewhere. And then finally, we do that because it is important for the independence of the judiciary that we show, that we demonstrate, again, to the other branches and to the public, that this is a process we go through, and it's the rule of law and not the rule of heck, which I prefer the rule of heck in some regards, but not everybody does. And so it's important that we make sure that that is understood. And then to remember, as our great friend Justice Scalia was careful to remind us all the time, that in interpreting these very important provisions, the provisions that matter so much to us as a people, it is important to remember a sense of judicial humility. If you were friends with Justice Scalia, you know he was personally a humble fellow, even though he could also be the opposite. But he was noted for that. And judicial humility is that same idea that some things are to be worked out by the people in the other two branches and not just the judiciary. The judicial independence is a very important concept today in Texas because of the last election and what it says about the politicization of our courts here and whether that process should be changed, which is your next session. And you've got a great day planned, and I wish you well. Thank you very much.
Good morning, and with that, we'd like to welcome our first panel to the stage. Well, my name is April Ferris, and it's an honor today to introduce you to our moderator, the Honorable Judge Jeff Brown. Judge Brown was sworn in earlier this week to serve as a judge on the United States District Court for the Southern District of Texas. Judge Brown has had a long and distinguished career in judicial service already. He has served as a judge in Texas since 2001, and he has served at all three levels of the Texas judiciary. Most recently, he served on the Supreme Court of Texas since his appointment by Governor Rick Perry in 2013. In 2014, he won a statewide election to retain the seat. Before reaching the High Court, Judge Brown served 6 years as a trial judge and 6 years as an appellate judge on Houston's 14th Court of Appeals. On March 11, 2019, President Donald Trump nominated Judge Brown to serve as the U.S. District Court, to serve as a judge on the District Court for the Southern District of Texas. The Senate confirmed him on July 31st of this year, and he received his commission in September. So with that, please welcome Judge Brown and our distinguished panelists.
Thank you, and thanks for the opportunity to come here and moderate this panel today. I think it's going to be a lively discussion among our panelists. I will briefly introduce the four of them from your right to your left in alphabetical order, and we'll learn a little bit about each one of them, and then we'll get started. And as I said, I think we expect a lively discussion on judicial selection this morning. But please understand that we will leave plenty of time for questions at the end too, because I know that y'all probably want to participate in this discussion as well. The first panelist I will introduce is Chris Bono. He is professor of political science at the University of Pittsburgh, co-founder of the Prison Education Project, and co-editor of State Politics and Policy Quarterly. He received his BA from Valparaiso and an MA from Ball State and an MA and PhD from Michigan State. Chris has authored 3 books. He has edited 2 others and published numerous scholarly articles and chapters on judicial politics, specifically the politics of state judicial selection. He is a frequent speaker before academics, attorneys, bar associations, and policymakers. Brian Fitzpatrick's research at Vanderbilt focuses on class action litigation, federal courts, judicial selection, and constitutional law. Professor Fitzpatrick joined Vanderbilt's law faculty in 2007 after serving as the John M. Olin Fellow at NYU School of Law. He graduated first in his class from Harvard Law School and went on to clerk for Judge O'Scanlan on the Ninth Circuit and Justice Scalia on the U.S. Supreme Court. Following his clerkships, Professor Fitzpatrick practiced commercial and appellate litigation at Sidley Austin in Washington and served as special counsel for Supreme Court nominations to U.S. Senator John Cornyn. And before earning his law degree, Professor Fitzpatrick graduated summa cum laude with a BS in chemical engineering from Notre Dame. He has received the Hall-Hartman Outstanding Professor Award, which recognizes excellence in classroom teaching. Lee Parsley has worked with Texans for lawsuit reform since 2002 and now serves as its general counsel. Lee leads a team of attorneys who help identify and research solutions to the challenges facing Texas legal system. His background in civil and appellate law has given him firsthand experience in navigating the Texas court system. His experience in the legislative process helps TLR engage with lawmakers and stakeholders to ensure that Texas is passing principled laws for a fair and efficient legal system. These last 2, Lee and Judge Phillips, are the 2 panelists I've known the longest. Lee and I met when I was a law clerk at the court, and he was rules attorney, I believe, at the time, back in the mid-'90s, I'm afraid. The Honorable Thomas R. Phillips, retired Chief Justice of the Supreme Court of Texas, joined the Austin office of Baker Botts in September of '05 after nearly a quarter century of service in the judiciary. After graduating from Baylor University and then Harvard Law School, he clerked for Rule Walker on the Supreme Court of Texas and practiced law in the trial department in the Houston office of Baker Botts. From 1981 to '88, he served as judge of the 280th District Court in Harris County, and from '88 to 2004, he was Chief Justice of the Texas Supreme Court. He was initially appointed to both posts by Governor William P. Clements. He was elected without opposition to the district bench in '82 and '86, and in contested races to the Supreme Court in '88, '90, '96, and '02. And that just tells part of the story, though. When Judge Phillips reached the Supreme Court in '88 as an appointee of Governor Clements, he was 38 years old. 38, is that right? 38 years old, the only Republican on an all-Democrat court, and one of the members of the court was running against him in that election in 1988, the very year that he was appointed to the court. With the help of Judge Hecht, who was elected to the court in '88 as well, he led the effort to both restore the reputation of the court following the Justice for Sale scandal and reform the judicial campaign finance system in Texas. He was chief when I clerked at the court and has long been one of my heroes. He later became a mentor of mine, and now I'm very proud to call him my friend and very pleased to have him on this panel today. So there's your panel. And we are going to start with a visual aid from Professor Fitzpatrick. And I need to give you this. The green button will advance the slides, I'm told.
Perfect. Thank you very much. I'm delighted to be here today. This was as close as I could get to the UT colors in my closet. So I hope you forgive me for not matching exactly. But, so I'm going to set the stage by giving us a little background about the various methods that states around the country use to select their judges. I'm also going to remind us of many of the considerations that we like to think about when we're deciding which of these methods is best. And I'm going to push upon you a new consideration that is sometimes not thought about in these discussions and share with you some data about that last consideration. But let's just start with some background about the selection method. So there's basically 4 different ways that states select their judges around the country. The original method in all of the states was political appointment. Almost all the states did the same thing the federal government did from the beginning. Some of them didn't have life tenure, but they all relied either on the legislature or the executive or both to pick their judges. A handful of states still follow the political appointment method today. In the early 1800s, states began to switch to partisan election away from political appointment, and by the time of the Civil War, the vast majority of states are using partisan elections to pick their judges, and today there are still quite a few states that use partisan elections to pick their judges. In the progressive era, they decided that politics was a bad thing, and so they developed the idea of nonpartisan elections for judges, where they took party identification off the ballot. And a number of states today are using nonpartisan elections. I think it is close to the most popular method today. The only method that may be more popular today is the method that came about last in our history, and that is the commission method. Sometimes it's called merit selection, sometimes it's called the Missouri Plan, because Missouri was the first state to adopt it in 1940. This method basically asks a commission to decide who is worthy to be placed onto the bench. The commission sends a small number of names, usually 3, to the governor, and the governor has to pick one of those names. The candidate then stays on the bench until the term is up, and most of these states use something called a retention election to decide whether to retain the judge. It's an election with no opponent. It just says yes, no, do you want to retain the judge? So this system, the commission system, is used in almost half the states today for high court judges. And so it is the most popular method, followed, I think, by nonpartisan elections, then partisan elections, and then political appointment. So those are the 4 options that are around the country still today. So when we're thinking about which of these methods is best, these are the factors that people usually weigh in their minds when they're thinking about this question. These are things that we want in our judges. We want independent judges. We've already heard some about that today from Justice Hecht. We also want our judges to feel somewhat accountable to the people or to the political process for the decisions they make, so they can't just do whatever they want to. We, of course, want competent judges, people who understand the law and who write well. A lot of people want racial and ethnic diversity, as well as gender diversity on their courts. Integrity, of course, we want honest judges, and we want the judges to work in a system that the people see as legitimate. These are the normal factors we hear from. I suspect we'll hear a lot of discussion about these factors today and which of the methods I put up there produces the best balance of these factors. But I want to spend a couple minutes to advocate for another factor that we often don't talk about in these discussions, but I think we should. And the last factor is something I called ideological skew. And what I mean by that is, are the courts filled with judges that have very different ideological views, very different values, very different worldviews from the people who live in their states? Now, you may think to yourself, well, who cares if they have different ideological views? Ideological views aren't supposed to matter when you're a judge. You're just supposed to follow the law. But we know there's a lot of empirical evidence that suggests that a judge's policy views, worldviews, values makes a difference to how the judge decides cases. Not in every case, but in a lot of cases. How you see the law is driven, especially when the law is ambiguous, by your ideological views. And so if you have judges that have very different views than the people in their states, you're going to get legal interpretations that are very different than the people might have wanted them to be. Now, why should we be concerned about this ideological skew? Well, this is why we should be concerned. This is a graph of the ideological views of the legal profession in the United States of America. And you probably, each bar on the graph represents a certain number of lawyers. On the left side, those are the more liberal lawyers. On the right side are the more conservative lawyers. And the little dotted line there is your average lawyer. And what you find is, this probably won't surprise people, that most lawyers are liberal. And the average lawyer is about Andrew Cuomo there. So what does this mean? Well, it means a couple things. Number one, if you have a selection method that relies on the legal profession to pick judges, I would submit to you there's a good chance the legal profession is going to pick judges with an ideological distribution much like that one, i.e. left-leaning. And of the 4 methods that I put up on the screen earlier, one of them, the commission method, tends to place a lot of power in the hands of the legal profession to pick judges. Why? Well, because the commissioners on the commission are often picked by the state bar. Some states, the state bar leadership appoints people to those commissions. Some states, the lawyers in the state vote for who should be on the commissions. Some states, it's a majority of the commissioners come from the bar picks. And that's a lot of power to give to the legal profession, and I'm concerned that they may pick judges that look like them instead of like the people in their states. But another thing to think about is this, because the pool of judges will be drawn from the pool of lawyers, if we do not pay attention to this, chances are, if we're just randomly picking judges out of a pool of lawyers, we're going to get judges, again, that look like this. If we don't screen for the worldview of the judges, we will replicate the distribution of the lawyers. And this isn't just a theory anymore, because I've spent several years trying to prove that selection methods that do not screen for ideology produce judges that are to the left of the people in their states. And this is what I've done. I have collected campaign contribution data of all of the people that have served as appellate judges in each state between 1990 and 2010. So over 3,000 different appellate judges. And I looked to see, did those appellate judges over the course of their lives, before they went on the bench or after they went on the bench at any time, did they give more money to Democrats or more money to Republicans? And then I compared the distribution of judges in each state to the people in each state. Were the people voting more for Democrats or more for Republicans in state races and federal races, what have you? And the middle line on this chart is if the judges and the people were the same distribution of left and right. Bars to the left are states where the judges are more liberal than the people. Bars to the right are states where judges are more conservative than the people. So a couple things to note. First of all, in the vast majority of states, the judges are more left-leaning than the people. And again, that's not surprising because lawyers are left-leaning. And if we don't pay attention to that, we end up with judges that are left-leaning. Very few states have judges that are right-leaning, but I will tell you, one of those states is Texas. The third state from the bottom there is Texas. And so is one of the very few states where the judges have been more conservative in those years than the people. Now, this is just every state in the country, and what I did was I grouped these states by selection method to see if, in fact, methods that rely on the legal profession to pick judges or methods like nonpartisan elections that have no screening at all for ideology produce more left-leaning skew. And that's what I found. And so here you see 4 bars. The top bar is the Missouri plan, commission method. The second bar there is nonpartisan elections. The third bar is partisan elections, and the fourth bar is political appointment. The middle line, again, is if the judges were the same as the people in terms of their ideological views. And what you see is the Missouri plan and nonpartisan elections have the biggest skew away from the people, and it's a skew to the left. The system that is the closest to the people is political appointment, and partisan elections are a little bit in between there. I'm just a simple country law professor, so I did not test any of this data for statistical significance and those kinds of things, but there are some people who have. There are two political scientists. One is named Adam Bonica, and the other is named Maya Sen. One's at Stanford, one's at Harvard. They've replicated this study with the campaign contribution data, and they have found that these differences are statistically significant. Methods of selection matter to who sits on your court, and I think we should pay attention to that. Thank you.
Thank you, Professor. And I want to encourage the panelists to chime in at any time to comment. We're going to hear in just a second from Lee on some proposals that were discussed in the legislature here in Texas in the last session. But before we do that, anybody have anything they want to throw back at Professor Fitzpatrick before we move on to Lee? Okay.
I'll wait my turn.
All right. Okay. Lee, what can you tell us?
Good morning. Thank you, everyone. Thanks to Federalist Society for inviting me today. There was some activity in the legislature this past session on judicial selection, and I want to cover that. That's not new to the legislature, by the way. They've tried several times over the years to pass some form of a change to how we select our judges in Texas. Robert Duncan, who was a state senator from Lubbock, coupled with Rodney Ellis, who was a state senator from Dallas area, and they tried maybe 4 different sessions to do something. They could usually get it through the Senate, and then it would fail in the House, and they tried, we'll change how we appoint everybody, we'll change how we select only the appellate court judges. So it's not new. Then it had kind of died off a little bit, and the last few legislatures had not considered this topic at all. But in the past legislative session, Brooks Landgraf from Odessa introduced a bill on, maybe if he didn't file it on the filing deadline for bills, he came very close, to change the selection method in Texas. He filed House Bill 4504 and accompanied it with a resolution number 148 for the constitutional amendments, because that's how we do things in Texas, that we bill for the statute changes and a resolution for amendments. But Representative Landgraf wanted to create a system where the governor would appoint all judges, district court, courts of appeals, and the high courts of Texas. The Senate would confirm. There would be a commission, so you've heard a little bit about commissions, but in the Landgraf bill, the commission would do more like what you hear happens on the federal level. That is, the commission would say the judge would evaluate the judge as either not qualified, qualified, or highly qualified, and provide that information and in their reasoning to the Senate as part of its confirmation process. So it wouldn't create a list for the governor in any sense. It would just evaluate whoever the governor had sent to the Senate for confirmation. There would be a judicial appointment advisory board that was going to have these 11 members to make these considerations. And they were appointed, some by the House, some by the Senate, some by the Chief Justice and the presiding judge of the Court of Criminal Appeals, some lawyers, some non-lawyers, slightly weighted. 6, as I said, there were 11 members, but they weighted it in this bill from 6 non-lawyers and 5 lawyers on that panel to try to make sure that it was at least slightly weighted towards non-lawyers, because I think Professor Fitzpatrick didn't talk about it, but I think these selection panels historically, when they have all lawyers on them, then I think their tendency is to go more left-leaning in their evaluation of things. So this was a panel that would have at least more non-lawyers than lawyers. The bill suggested retention elections and a term limit of 12 years. And as I said, it applied to pretty much all the courts in Texas. Back to Justice Heck's comments earlier, you know, the question is how much of this do you put in the Constitution and how much of it do you put just in statute? So for example, this bill put the 12-year term limit as a constitutional matter. Now, a judge could be reappointed after the 12 years, but 12 years you were up if you survived your retention elections along the way. But that was a constitutional matter, so they wanted to make it, at least Representative Landgraf wanted to make it where it was difficult to change that 12-year requirement. Now, you all may know this already, but I'll emphasize that in order to pass a constitutional amendment in Texas, it takes 2/3 vote in both the House and the Senate. Right now, in terms of the partisan divide of the Texas legislature, the Senate is sort of close to 2/3 Republicans and 1/3 Democrat, but there's not 2/3 Republicans. It'd have to be Democrat support for any proposal. The House is not even that close, so there's got to be quite a bit of support for any proposal. I'll tell you that the rural areas of Texas don't think that they really have a problem in how they select their judges. They think they're doing just fine out there. They think the problem exists only in the urban areas. So this bill exempted all, for district court, trial court judges, if your county had 500,000 or fewer people in it, you just kept on electing your judges. You didn't have to go through this process with the governor appointing your judges. So that was an attempt to kind of rake in, you know, the rural Republicans largely. I mean, you go to the panhandle of Texas, where I'm from originally, and you ask them, well, do you need some help from the governor in Austin to pick your judges? And they, not so many of them are signing up for that. So, you know, there's not very many counties west of I-35 that have more than 500,000 people in it. So essentially, west of I-35, you know, they were going to keep doing what they were doing under this bill. And Odessa, as you all might know, is west of I-35. So Brooks Landgraf's people were going to get to keep doing what they're doing, which probably was more likely to ensure he would return to the legislature. But that, you know, it's a valid question. There are states that do it where they have that kind of, you know, population line, and you select differently below that population line. There was also another bill that had to do with judicial selection in kind of an odd way. House Bill 4149 by Representative Leach, who was chairman of the House Judiciary Committee this past session. He had a business courts bill. Again, it was filed very late, right at the deadline. And he had a business courts bill, and he wanted to create a business court system in Texas, and that court was going to hear, for example, derivative actions and shareholder lawsuits and anything that challenged the structure of the organization, and $10 million valued cases between businesses, so it exempted personal injury and family law. So, you know, it's trying to draw a line between what's a business dispute and what's a personal injury and family law kind of thing, and wills and estates. But he wanted to create business courts, and there were going to be seven members of the business court. It's going to be a statewide jurisdiction court appointed, because you can read the Texas Constitution to say that if you create a new court like this, you don't have to elect them. You can just appoint them. So this had a 7-member appointed body, appointed by the governor, but the governor there was going to be a panel that sent the governor 5 names, and the governor could choose from those 5 names or ask for 5 more. But the governor would appoint a panel that would tell him, here are 5 people, and you can get 5 more. So he'd have up to 10 names to choose from. So it was really kind of an entirely different system. It was more like the commission you talk about. Many of these commissions around the country give the appointing authority a list of names, and they must choose from that list of names. But the difference here is the governor got to name the people on the commission, so that seems a little circular to me, right? So you name the people on commission. My guess is if you don't give the governor the 5 names he wants, you get unnamed, right? He just names a new commission, and after a while, he begins to get the appointees he wants. So that seemed a lot like a sort of a not very overt. The governor just gets to pick these judges to go on that. That bill failed, and Landgraf's bill obviously failed too. What did pass was House Bill 3040 by Hunter from Corpus Christi. And Chairman Hunter used to be chairman of the House Calendars Committee, which is a very powerful position. He wasn't in this past session, but he's still a long-tenured member, and he did get the legislature to pass a bill that establishes the Texas Commission on Judicial Elections, or Judicial Selection, 15 members, 4 appointed by the governor, 4 by the lieutenant governor, 4 by the speaker, 1 by the state bar, 1 by the chief justice of the Supreme Court, 1 by the presiding judge of the Court of Criminal Appeals. And that commission is supposed to report to the governor and the legislature by the end of 2020 on its evaluation of other possible selection methods for Texas. So it is just a study. It is just let's talk about some other possibilities, and that is ongoing. Now, I think the Supreme Court has named its member to the panel. I think the Court of Criminal Appeals has named its member to the panel. The governor, the lieutenant governor, and the speaker are supposed to cooperate to give some geographic diversity, some diversity in all ways to this panel. And the governor, I think, has been a little distracted because we've had some unfortunate events in Odessa and El Paso that I think have had the governor's attention. The Speaker of the House has been distracted for other reasons. So at this moment, that panel has not been appointed. But because we knew it was coming, and since we're in Austin, the book will be orange colored, the Texans for Lawsuit Reform Foundation will be publishing a 50-state survey of how judges are selected around the nation, like Professor Fitzpatrick was talking about. The methods for selection, we include a method for evaluation. He had, I think, 7 points up there. Our evaluation criteria, I think, focus on 4 different things. We make no recommendation in this report. We just are compiling everybody else's work from around the country for the last 50 years or so into a single report to try to get the commission, when it gets named, the basic information it needs to begin to evaluate Texas as compared to everywhere else. And the last thing I'll note is Texas is one of only 6 states that does partisan elections for all its judges. We're down to 6 of us: Alabama, Illinois, Louisiana, North Carolina, Pennsylvania, and Texas. I want to let our panel move on, but I've got some evaluation about how that partisan election has done, and at least in my look at it last night in the middle of the night. So with that, I'll turn it over to Judge Brown.
And Lee mentioned that a constitutional amendment requires 2/3 vote in the House and the Senate, and then also a statewide referendum.
That's right.
And I believe that TLR has done research before showing that the thought is the people would be very reluctant in a constitutional referendum to give up their right to elect their judges.
Yeah, all polling, we did some polling specifically on that question probably a decade ago, and talked to some consultants about it, and I don't remember the number, but it was, our consultants, I think, thought it would take something akin to a $12 million campaign in Texas to convince the voters to vote for a constitutional amendment to do this, and then that $12 million might get it done and it might not, right? So they were, the voters polling has historically been pretty solidly in favor of continuing to elect their judges.
And I want to go to Chief Justice Phillips next, and Chief, talk about whatever you want to talk about, but please specifically address, if you don't mind, what might be done if judicial selection is something that Texas wanted to do, selection reform. What might be done short that would not require a constitutional amendment?
I'm glad. Well, there has been an ongoing interest ever since the Constitution of 1875 was adopted in the way we select judges. And Governor Koch said these elections are a disaster, but the Constitution's so good and so much better than the Reconstruction Constitution. You vote for it and I'll change judicial selection next session. And then the session elected him a senator instead, and he went off to Washington. And this issue's been being discussed on and off in Texas now for close to 150 years, with a lot of different plans suggested at various times. There is widespread dissatisfaction with the Texas system. Many of you all have probably experienced that, and you've certainly read about it. The Chamber of Commerce survey always has Texas near the bottom of the states in a desirable jurisdiction in which to do business with the legal system. I think we're 46th right now. We are ahead of Alabama and Louisiana, which are the two other states that both elect and re-elect all their judges in a partisan system. So in the flight we're choosing to play in, we're number one. But some people have wondered if there was another system. I see three big problems with the system we have. The first is qualifications. You really just have to not be in jail and be breathing to be eligible to be a judge in Texas. And our qualifications are more stringent than those in many states. But after the Judge Manfield, who had a law degree but for 9 years was an actuary for a New England insurance company, and then came down to Texas and had one case, and that was in a traffic court. And the courts ruled he met our 10 years to be an appellate judge requisite. You know, the school's pretty much out on that. So qualifications we worry about. Money in politics we worry about, and Judge Hecht and I are certainly grateful for the money in politics because the CBS show Justice for Sale is what got us elected. But there was some concern, for instance, when judges vote one way, get a $120,000 contribution from the losing litigant, and vote the other way on rehearing, as my opponent did. He said the money didn't influence him, and I take him at his word, but it didn't look good in terms of building public confidence. And then the third is security of tenure. We had 40 contested appellate races, I think, on the ballot last year for our courts of appeals. In 32 of those, the incumbent Republican lost to a Democratic challenger. Before 2004, every judge in Harris and Dallas County at the district court level was Republican. Now it's 0. So it's not a job that you can really plan for the future on. And so we have good judges going to these boring post office judgeships. And you can't blame them. But we are the second biggest state in the union, you know, and California had a federal district judge leave to join its Supreme Court, and Malcolm Lucas, and Judge Cardozo, was it? It was Learned Hand, who was a federal judge who ran for the New York state courts. We haven't had that in Texas. So constitutional amendments are tough, but there are things that could be looked at just by statute. And I'm just going to run through 6 of them. One is nonpartisan elections, which have their own huge sets of problems, but I suspect that not all of those judges would have been opposed had it been a nonpartisan race, particularly given the difficulty of getting signatures and the other ballot access mechanisms we have in Texas. And a lot of southern states, as they have become more two-party systems, have gone to a nonpartisan election, and they doesn't seem to have been a massive disaster. The second is a spinoff of that, and it's cross-filing. And that would be to allow or require judicial candidates to run in both party primaries. And in the glorious days of YouTube, probably you wouldn't have judges going, as they frequently do now, and say, you know, vote for me, and I'll see that the platform of this political party is somehow infused into many of my judicial decisions. And I would think that judges being, the political parties would get double the filing fees, so they might be able, and their crowds would increase at some of their events. So they might be able to be bought off on that, and the judges would meet a larger group of voters and would remember that they're responsible. Their constituency is principally the law and not some group, a particular group. Texas had cross-filing in 1952, and we survived. New York and California have a lot longer experience. Their experience lasted longer. Third would be enhanced filing requirements. We have signatures statewide and in and courts of appeals in the urban areas. But one of the new Democratic judges in Dallas suggests this idea. In other words, it's fixed now what it takes to be a judge, but ballot access we've done things with, like the signatures. And then once you get in office, the Supreme Court, at the direction of the legislature, mandated that judges have a certain amount of judicial education, and if not, they can be removed. So there is some play in the joints on both how you get on the ballot and then what you must do to stay there. A newly elected Democratic judge in Dallas, who happens to be board certified, suggested this idea. Before you file a treasurer designation, which you have to do before you can raise money to run for judge, you must certify that you have sat for the exam of board certification in one of the areas that your court has jurisdiction over. Now, it's a secret score, but you have to have sat for it. And then if you pay your filing fee and want to be on the ballot, your score pops up on the internet. It does not keep you from being, you can make a 0 on that test and the voters can choose for you to be in office, but you better win because you might not get hired much as a lawyer if you lose. On the back end, it could be an ethical requirement that you sit for some test or, show that you know who has the burden of proof in a criminal case or whatever else test you wanted to set up. Fourth idea is Lee's already talked about, and that's creating some courts with limited jurisdiction in areas where there have been some high press, like maybe Pennzoil versus Texaco from another generation. Courts with a judge selected a different way that could handle some specialized cases that aren't just the kind of case the ordinary litigant has intersects with the court system in. A fifth issue is redistricting. We've not had comprehensive trial court redistricting since 1883. We just added courts on, and then our appellate court districts are basically drawn based on where you can get from your house to the courthouse on the railroad system of Texas. So, the Austin court is long and thin because the railroads tended to run more east-west from the coast to coast than they ran north-south. The Austin district stretches way out to past San Angelo. And the Houston district used to go up nearly to Austin. They've cut a little of it off now. But anyway, looking at redistricting, why do we have 14 courts of appeals and no other state has more than 6? Well, it's because we were big and you just didn't want to be on your horse for too many days getting to court. So really being at the southwest hubs is more important than, say, being there in Eastland where the oil boom was and that petered out in the late 20s. And finally, you could revamp our administrative judge system. Right now, when you have that election certificate in Texas, you're kingfish of your own lodge. But in many states, there, for instance, is only one level of trial court. So somebody who runs a bagel shop gets elected district judge, as happened in California a few years ago, and that's fine, and congratulations, and the administrative judge sends you to the traffic docket for the next 20 years. So if you had a stronger administrative system, perhaps there would not be as many litigants who feel that they are stuck in a court that has no idea what they're talking about. And 2 cases I've had since I came back into practice, it was 4 years after the verdict came in before the judge would sign a judgment. The judge kept sending you to his law school roommate for mediation because they just really didn't want an appellate court to be looking at what happened. So there's a lot that could be done if you think that tenure and competency and to a lesser extent the huge money that goes along with these judicial elections are a problem for our state. There's a lot that could be done legislatively. And I hope as the commission looks into this that the best doesn't become the enemy of the good.
Go ahead.
Judge, would you mind if I just chimed in for a second before we got to Professor Bonu? I just wanted to pick up on something that Justice Phillips said there, and that is that constitutional amendments are hard. There's no doubt about that. In Tennessee, where I'm from, we have a process very similar to yours on what needs to happen to amend the Constitution. But we did it in Tennessee just a few years ago. We changed the way we select judges there by constitutional amendment. We got rid of our commission system, and we replaced it with political appointment. Now, you're going from elections to something else, and so it's maybe a heavier lift to get the people to change elections into something else. But I'll tell you, I think it's worth it. I think it's worth getting rid of elections for one of the reasons that Professor Phillips noted, and that is, Justice Phillips noted, and that is money. The money is an intractable problem with elections, and it influences how the people see the courts. They think court decisions are illegitimate if they find out that one of the litigants or one of the lawyers donated money to the judges. And just to nail that point home, I want to read to you a short paragraph from a letter that I read every year to my civil procedure class when we talk about diversity jurisdiction and why corporations do not want to be in state courts. This is a letter from a Texas lawyer. I think many of you have probably heard of him. His name is Michael Watts.
My old law clerk.
And he wrote a demand letter to an out-of-state corporation where he wanted them to settle a case for $60 million. And it's a 13-page letter, but on page 7, he gets to the appellate courts in Corpus Christi, where any appeal from a trial judgment will be heard. And they said, it's very important in evaluating the settlement value of this case to look at the appellate courts where the judgment will be reviewed if the case is successfully tried to verdict. This case will go to the 13th Court of Appeals sitting in Corpus Christi. This court is comprised of 6 justices, all of whom, he notes, are good Democrats. The Chief Justice was recently elected with our firm's heavy support. Justice so-and-so, also recently elected with our firm's heavy support. Our firm has also been very pleased with Justices so-and-so, so-and-so, and so-and-so, all of whom we have supported in the past. The 6th judge is more conservative than the others, but has been a friend of mine for many years. We are currently involved in the effort to get him reelected. So I just don't know how you solve this problem, whether it's partisan elections or nonpartisan elections. This, to me, is something that cannot be tolerated and cannot be overcome, and that's why I like the federal system. I like political appointment.
I clerked with Michael Watts at a law firm in Austin when he and I both were in law school in different places. I was at Texas Tech, he was at Texas, and he was just as humble then.
All right,
I guess I'll tell a story too. I'm sorry. Michael's a friend of mine, but he has a good work ethic. I don't think he'd mind this story. After he would put in a full day for me, writing opinions the way I saw, he would go over to the other chambers and work on a dissent against my opinion. And I called him in and said, this is your rice bowl here. And he said, I always try to write yours better than I did.
Just as humble then.
Well, we have been talking about judicial selection reform, possibly changing the way that we elect our judges or select our judges in Texas. Professor Bono is an advocate for keeping things the way they are. Professor Fitzpatrick has thrown the pitch. You care to swing your bat, Professor?
Yeah, I mean, I don't know Michael Watts, but I wish I did. Brian and I have been doing this dog and pony show for a number of years, so I'm kind of like the turd in the punch bowl here. I'm not a lawyer. I'm not from Texas, and neither one particularly bothers me. So I want to start by saying that there's no one perfect system for selecting judges, and I think you've kind of gotten that from everything that's been discussed. That each system has their strengths and their weaknesses. And partisan elections have come and beat up a little bit here, so I'm going to talk a little bit about their strengths and one of the reasons why I think they work very well. The other thing I want to start by saying is that, for the most part, the data that I'm talking about, or Brian's talking about, whatever else, is limited to state Supreme Courts and state courts of last resort. When you get down the level to like trial courts and everything else, we really don't have a lot of good data and good analysis of what's going on there. And so it's perfectly reasonable for a state to have different methods of selection for different levels of courts. And we see some states that do that, like California and New York, and that's a perfectly, reasonable way to go. And then the final thing I'll say as a preface is that each state should be free to do what they want and free to do what works best for them. And when I give talks in states that appoint judges, and I show them some ads that have been run in these elections, they're horrified. Like, oh my God, judges do this in states? I'm like, yeah, and people in those states, they're used to it, right? In Texas, right, you don't think anything about seeing, a hard-hitting negative ad, for a state Supreme Court race. It's part of what's baked into the system of how you do judges. And so each state is free to determine what their needs are, what they want their judges to be, what their desires are, and go from there. So, I live in Pennsylvania, so whatever happens here is, is cool. So let me talk a little bit about the case for partisan elections, and I will talk about some ways we can reform partisan elections that are short of eliminating them, but may get at some of the problems that have been raised earlier. So it's always struck me as odd from a political science point of view when you look at institutions of government and where institutions of government get their power from. So the governor or the president gets their power because they're elected from the people. Members of Congress, members of the Senate get their authority because they're elected from the people. The judiciary, the third, co-equal, I would argue supreme branch of government, in a federal system gets its power from the other two branches of government, which strikes me as a bit odd, because then the decisions made by those other two branches of government are kind of tied up with how things work in the judiciary. And so one of the great things about electing judges is the authority of those judges and the legitimacy of those judges comes from the people, the same source of power with the other two branches of government. And as was mentioned already, voters like elections. In states where they've commissioned polls, it's anywhere from 2/3 to 3/4 of voters like electing judges. And they say they want to keep on electing judges, and they don't want to lose the right to elect judges. So there's a very high degree of support. I mean, 12 million seems like a low number to try and move that. When you put a constitutional amendment on the ballot, so we want you to vote on this amendment to not vote on something else. It's a really tough sell, I think, and voters, it's hard to move, particularly now. So it's not just that voters like elections, but voters actually participate in these elections. So if you look at, one of the criticisms of partisan elections or judicial elections in general is that voters don't participate. They simply, vote for the other offices and don't. But in partisan election states, particularly, states with straight ticket voting like Texas has had for a while, but apparently is eliminating in 2020, which is, as an aside, really exciting for me because I have a paper that I wrote in 2014 on straight ticket voting, its effect on judicial elections. There were no partisan states that didn't have straight ticket voting. And so now actually I have another paper, so that's good. So thank you, Texas. But voters participate. If you look at partisan election states, the amount of roll-off, so given that people turn out to vote, do they vote for judges? The average is only about 8% roll-off. You have higher participation in these statewide races than you do in a bunch of other races. And Texas, of course, is famous for their long ballots, or I believe, and some will cover, you still elect the Railroad Commission in Texas, which is a very important office. Not sure if it needs to be elected or not, but so you're famous for your long ballots. Voters participate in these judicial elections. And they participate meaningfully. Voters are able to distinguish between candidates, who are closer to them in terms of policy preferences and also that are more qualified. So if you look at state Supreme Court elections, candidates who are running, if you look at challenges to incumbents, challengers to incumbents who have prior judicial experience perform about 5 points better than challengers without such experience. Now, there are other sources of qualifications besides just judicial experience. But the fact is that other things being equal, candidates who have that prior judicial experience perform better than those without it suggests, pretty highly suggestive that voters are able to distinguish between candidates on the ballot. And candidates that have experience are able to do better. Again, this is at the state Supreme Court level. I'm not going to make any claims at the trial court level. Again, Steve Mansfield's always a bad example because there's always one. Or two. And there are other factors. But voters are able to participate meaningfully. There's also no difference in the quality of judges you get on average. Right? You get the same quality of judges, whether you measure quality by how often they're overturned at higher levels, whether it's where they get their law degrees from or anything else. There's no difference in the quality of judges you get in partisan elections. And also, while legitimacy is a very important concern, there's no difference in legitimacy. Right? That is, elections have a legitimacy conferring capacity that, there have been some political scientists who have done wave studies. And so the most famous one was done in Kentucky, where there's a survey done about 2 months before the election and was done right after the election. And then a third wave was done 2 months after the election. And what this political scientist, Jim Gibson, found is that legitimacy actually increased among people. Right? Elections, right, there's a cost, right? And people are concerned about campaign finance and campaign spending. But the electoral process itself, right, confers legitimacy on the institution. And people, right, they participate in the process, they regard the results as valid, that gives the institution legitimacy. So what kind of reforms could we have that would, because, Brian's right, that the big concern is money and the perception of impropriety. The good thing is there's no actual evidence of impropriety at a systematic level. That is, there's no systematic evidence to suggest that judges changed their votes based on their campaign contributors. Rather, much like for members of Congress or Senate, what's happening is donors are giving to like-minded judges. Right? If you're giving money to a judge, you're going to give money to a judge who agrees with your philosophy of the law, or you're going to give money to a judge trying to change his or her philosophy of the law. Right? The former is far more effective. So one reform is something that's been tried in North Carolina and had pretty good success, and West Virginia has also gone to it, is public financing of elections. Now, North Carolina ended their public financing of elections several years ago, but in their 8 years of having it, they had participation by about 3/4 of the candidates, and they were able to provide enough funds for candidates who received public financing to compete and win against candidates who opted out of the public financing system. Again, West Virginia has done this now for 2 election cycles, and it seems to be having the same kind of effect in West Virginia. Another reform is you could go to a single term of office, so judges don't have to worry about re-election. So if you went to a single 18-year term of office, then judges would not have to be worried about campaigning for re-election, about raising money from people who could be coming before the court, and that would eliminate some of the concerns. You could also go to just a single term regardless of how long. I mean, I would not advocate for life tenure. Tenure is only reserved for university professors, as it should be. You could change qualifications. So you could, you could pass a law, making qualifications to run for judge or to serve on a court or a particular court much more stringent, right? If we're worried about people who aren't meeting qualifications or we're getting people who aren't qualified on the court. And then one thing I just want to say regarding nonpartisan elections is, Brian and I disagree on a lot, but I think we both agree that nonpartisan elections are the worst. But again, if you want to do it, you can.
It's the worst after the commission method.
Yes, fair. Yeah, commission's the devil. Yes, that's right. Yes. But nonpartisan elections don't remove partisan characteristics. And so one of the things one of my co-authors and I did in our last book is we ran a series of experiments using actual ads that were run in states. And in some states, what we did is we treated voters with the partisanship of the candidate as well. And then in other voters, we ran the same ads that were run, actual ads in elections, and we didn't tell them who was a Democrat, who was a Republican. And what you find is that when you tell people who the partisanship of the candidates, about 95% of Republicans vote for Republicans, about 95% of Democrats vote for Democrats. When you take that out, the numbers drop to about 82%. Voters can still tell. Right? You can signal in ads without saying the party ID, and voters are able to tell. So yes, there is a drop, but the difference is still statistically significant, right? Absent partisan cues or whatever else, you would expect it to be split, right? You would expect Republicans and Democrats to equally choose each candidate, right? But in these ads that are run in nonpartisan states, there are ways to signal voters, and voters can tell. So you're not going to remove the partisanship. What you are going to do with nonpartisan elections is you're going to decrease voter participation because you're going to have voters who just don't know enough, and so they're going to say, I'm not going to vote. Right? Party ID on the ballot is a meaningful cue. We would not say we should take party ID off for congressional races or for senatorial races, because it means something. And as Brian said earlier, Republican judges and Democratic judges look at the law differently. And that's okay. I mean, I know a lot of lawyers and judges get defensive when they hear that. I mean, you're not bad people. It's okay. I mean, how we view our world experiences, our background, how we view things affects how we see things. And that's okay. So let's just be transparent about it. Well, when you're dealing with cases that come to state Supreme Courts, you're dealing with tough cases. You're dealing with cases where the law is ambiguous. If things weren't ambiguous, it wouldn't get to you. It would have been dismissed long ago. And so given the ambiguity and given how to interpret the law, why not give the voters the information they need to say, you know what, I want a judge who looks at the law, you know, like consistent with a conservative judicial philosophy. Or I want a judge who looks at the law consistent with a liberal judicial philosophy. Put it out there, right? If you take partisanship off the bat, you're taking away the most important cue, right? Because these labels mean something. And so that will be the end of my, oh, I have one more thing, but actually someone mentioned it, about judicial performance evaluations, which are a common, which are becoming more common, particularly in states that adopt the commission method, where you have either the bar or you have litigants evaluate judges and they release these things to the public. We need to be very, very careful of these things. Right, so some political scientists have looked at that, looking at racial and gender bias in these evaluations. Right, not surprising, right, for those of you who teach, you know about the gender and racial bias in teaching evaluations. These judicial performance evaluations are bad news. Controlling for all other things like reversal rate, education, everything else, women performed about 10 points worse than men, and African Americans performed about 14 points worse than whites. So these evaluations, right, if we're concerned about diversity in the bench, if we're concerned about having a bench that's reflective of the population, we need to be very, very careful about using these evaluations, because there is definitely a racial and gender bias in how these things are conducted. So.
Can I say one thing, Judge Brown, and that is, I think there is some promise to single terms to remedy the problem of money in elections, so I think that is an interesting suggestion that's worth thinking about. But I don't think public financing is a solution to the money in elections problem, and the reason is very simple. It's called independent expenditures. You cannot constitutionally, as we all know, prohibit Michael Watts from spending money independently to re-elect these judges. And as long as that is possible, the same problems of perception of impropriety exist.
Lee, you said that you had done some research last night on the results of partisan elections in other states.
Well, I looked at,
You wanted to share?
yeah, so I looked at, I started with the 6 states that have partisan elections for all their judges, which again, Alabama, Illinois, Louisiana, North Carolina, Pennsylvania, Texas, those are the 6. And then I looked at the U.S. Chamber of Commerce Institute for Legal Reform's ranking of states, their judiciary, which Chief Justice Phillips referred to, and he said Texas is low on that ranking, and it is usually low. So the 6 states, the absolute worst, according to the Institute for Legal Reform, Louisiana, partisan elections. Close to that is Illinois. It's 48th on ILR's list, partisan elections. Alabama's 43rd on the list. Texas is 39th on the list. Yeah, we're up to 39. Pennsylvania's 38, and North Carolina's 33. So the states that do just straight up partisan elections on ILR's list of rankings are all in the bottom third. So I thought, well, let's go look at the American Tort Reform Association's judicial hellholes and see what they show. So the judicial hellholes, according to ATRA, there are 9 places on there. They've just added Oklahoma. I didn't read it, but I could assume why they added Oklahoma. But anyway, so their places, their top hellhole is California. It ranks 47th on ILR's ranking, so they're getting similar results. Florida's on their list. It's 46th on ILR's ranking. St. Louis is in Missouri. St. Louis is one of their hellholes. It's 49th. They have Louisiana on their list. Again, it's 50th on ILR rankings. Madison and St. Clair counties, Illinois is 48th on the ranking. So in other words, the hellhole rankings in ILR are kind of in the same spot. So I look, California, the governor appoints with a board confirmation, so it's an appointment state. Florida, the governor appoints the appellate courts, but it has nonpartisan elections for its trial courts. So I did that analysis in each of the states on the judicial hellhole list. And what you find is that out of the 9 states on the judicial hellhole list, 7 of the 9 either are partisan elections or nonpartisan elections, at least at the trial court level, which is where the problems are. St. Louis, Missouri's problems in its trial courts, mostly. And those are nonpartisan, those are partisan election, I guess they are. So nonpartisan and partisan elections end up on the lower end of ILR's list. They end up on the judicial hellholes, more likely to be elected judges, frankly. So I did the top 10. I looked at the ILR's best states. Nonpartisan elections show up twice on the top 10 of ILR's best states to litigate in, but mostly those are appointed states. So I don't know, it's what the professor said, it's difficult to evaluate. How do you decide one system's better than another? The evaluation criteria are very difficult to get your arms around as far as I can tell. This is the best I could sort of come up with, is just look at people who aren't evaluating based on selection methods, but based on places where you really don't want to have to go litigate. And then when you compare that to the selection method, you find that the elections are skewing towards the bottom, and gubernatorial appointments are skewing towards the top, it seems to me.
I think we're about ready to turn it over to questions from the audience, unless any of the panelists have anything they want to add right here at the.
I'll add one last thing, to cap off how hard it is to get the Texas legislature to do something, much less 2/3 vote. The Railroad Commission in Texas, Professor, does not regulate railroads. Hasn't for about 50 or 60 years, Chief. Long time.
Well, certainly since
What the
1978.
hell do they do?
We regulate oil and gas through the Railroad Commission. But
Really?
the legislature, for several times, just by a majority vote, the legislature has tried to rename the commission, something like Energy Commission.
Yeah, right.
Right?
Yeah.
Can't pass it. Can't even get a majority vote.
See, this makes a lot of sense because, when I look at data or whatever, I'm like, who in the hell is electing railroads in 2000 or 2005? This makes sense now because you want the energy, right? That makes sense to have it elected. But
Yeah, and it's an important position.
Yeah, right.
And just a majority vote, you can't get to 50% of both houses to change the name of a commission that hadn't done what it says it's done for 50 years.
And,
I'm so glad I came today.
and I do think our short terms are problematic in terms of how often you have to raise money, in terms of how long the ballot gets. There can be, somebody from Houston, 70 contested races or so, judicial races on the ballot. But talk about an unpopular initiative with the voters. Mississippi tried to just add 2 years to its term. The case constitutional amendment didn't pass. But I do think there's going to be politics in how you select a judge, any of these methods. But the retention of the judge, it would be very nice if there were a system where you weren't retained at all, one term and a pension, like the constitutional courts across the world, except for ours, have those limited non-reappointable terms, or if that retention was some other method. And some states, 3, do have initial elections, open election, any comers. And then if you want to stay again, like in Pennsylvania, it's a retention election, which usually is an easier job. The other good thing about a retention election is every judge gets voted on. And there is at least a limited study that showed that judges showed up better and said less discourteous things to jurors and witnesses in the 18 months prior to the election. I don't think it was a widespread study, but I did see one like that. So the retention election has some benefit on the judge and on the people. You get to vote on everybody. So, but again, that takes a constitutional amendment, and I'm just not excited about any constitutional amendment except perhaps to raise qualifications, being able to be worded in a way that might cause people to vote for it.
Yeah, and the single term has actually been floated by some law professors for years at the U.S. Supreme Court level, too. A single 18-year non-renewable term so that every 2 years there's a new appointment, which has the advantage, one, of getting rid of life tenure, which we can get into a whole panel discussion about why that's life tenure is problematic. But it also, right, depoliticizes it from the presidential election campaigns as well. And so if you know that every 4 years there's going to be 2 appointments, no matter what, right, it kind of takes down the rhetoric and the politics, right, that have been going on. And so in Texas, with a 9-member Supreme Court, you could have the same thing. You could have, a single 18-year term, and then every 2 years, somebody else, right? So you always get new blood in there, but you retain a lot of institutional memory. And so that's something that's not, it's been floated at the federal level, which of course would require a constitutional amendment, which won't happen, but it's something people have been thinking about for, some years now.
Can I ask the Texans on the panel a question, and that is it fair to say that the concern with elections is directed more towards the non-Supreme Court justices, and that people are happier with elections as they're working with the Supreme Court?
Well, the Supreme Court's the races that at least in the 80s and 90s attracted the most money, and that was all money from within Texas. I mean, I think when our state becomes competitive again politically, which may be right soon, there's going to be all this outside money that has infected other states. We could have $20 million Supreme Court races. So that's disturbing to people. Mm-hmm. But from a philosophical basis, if you don't know who's running for a statewide court, it's kind of the voter's fault, because you can find the information out. And when these races are high salience, we had a lot of ticket splitting in the 80s and 90s. In fact, we had a number of elections where different people won different races. The courts make a lot of policy, and I don't mean in judging the unclear cases. I mean, the Supreme Court appoints, 33 boards. It writes the rules of evidence, procedure, and administration, and that is sort of a legislative function. I mean, they write the professional ethics rules for lawyers. So I don't really have an objection to that job being elected, and not too much of even a partisan label objection. It's really more there, the money.
Yeah, and that's a good point, I think, with the policy-making court versus non-policy-making courts. And even though trial court judges make some policy and they have some discretion, right, they're much more constrained, and there's an appeal. But at the Texas Supreme Court level, if it's a matter of state law, there's no appeal. It's the court of last resort. And so it's very much, you can think of a system where the Supreme Court should be elected and then lower courts should be selected via some other way.
Well, part of the answer to your question is we've got 2 high courts in Texas.
That's right.
We're an unusual state like that. We've got a high court for criminal cases, Court of Criminal Appeals, and a high court for civil cases. And so the Supreme Court draws attention and money in the elections, and the voters can be informed because there's enough going on politically there. The Court of Criminal Appeals, they decide life and death. The death penalty cases go straight to that court. They truly are deciding whether you're going to the electric chair or not, and that's a real threat in Texas, by the way, right? I mean, if you can, you can go to the electric chair, and that court draws virtually no voter participation. They can't raise any money. Both the incumbents and the challengers are just campaigning. They'll go to 3 or 4 places and just give up almost.
They've been saved by the signature requirements, which is 50 voters sign your petition in each of the 14 Court of Appeals districts. And we used to have 6, 7, 8 candidates running for that court, and ballot position or having the same name as a popular entertainer or something was just critical. Qualifications can help that court. Supreme Court doesn't make much difference. I mean, if you want to be on the ballot, you can generally get on.
Yeah, it's interesting if you look at the Texas Court of Criminal Appeals. So voter participation is about the same, probably because of straight ticket voting historically. But if you look at the amount of money raised, there's about 10 times more raised per seat for the Texas Supreme Court than there is for Texas Court of Criminal Appeals. And the only other state that does that is Oklahoma, your good friends to the north. And they use retention elections, so it's not really a good comparison. So Texas is the only state that elects judges that has that split. But even though I believe salaries are the same right across both courts and resources and whatever else, but 10 times more money for the Texas Supreme Court is spent and raised than for the Texas Court of Criminal Appeals.
They're just friendlier people, I guess.
That or Michael Watts, for some reason, is not interested in the criminal court.
Well,
I kinda feel like
he
he
did
should
have
be
a criminal prosecution for a period of time, so his interest level might have
He should
gone
be on
up.
this panel, right? Is he still with us? I mean,
So we have a few minutes left for questions from the crowd. Alfred.
Judge Brown, we heard about the new mandated commission. I wonder if Chief Justice Phillips, you might comment on prior commissions. Anything you'd like for those experiences?
Oh, yeah, it's kind of a depressing litany. Governor Bullock, after the Rene Haas Raul Gonzalez race in 1994, which is still the most expensive judicial race in Texas history, great ads, we don't have time to talk about. Anyway, he created a commission and was going to just ram it through. And Governor Bush was hesitant because he didn't like what he'd heard of the merit selection experience in Florida. And so Bullock pulled it down with some colorful language, which I can't quote here. Prior to that, there was a fairly big push in the 80s, headed by Senator Ray Farabee, that came past one house, was getting some traction. Then in the 70s, Chief Justice Calvert left the court and became the head of the Constitutional Revision Commission, which sent a constitution to the legislature, who sat as a constitutional convention, and it actually adopted merit selection for the appellate courts. That was defeated by the voters when Governor Briscoe came out against it. In the 50s and 60s, the state bar did a number of referenda on how to choose judges. The Missouri plan was when it was getting adopted by a lot of states, and there was a real push made for that in Texas. Through studies. In the 40s came out what I used to regard as the best plan ever. It was from Dean McCormick at UT Law School, which was the governor chooses the Chief Justice chooses all the other judges in the state. Only Nathan Hecht is for that one right now. And finally, in the teens, Roscoe Pound came down and was paid by the Texas Bar Association, it was called then, to clean up our ridiculously complicated judicial system. And he had a plan, which I recall was to unify the criminal and civil courts and have them sit in divisions with the Chief Justice just kind of as a pinch hitter. But elections were not a huge problem then. The most stable period the court ever had was from after 1894, when there was a huge, massive fistfight extravaganza over a judicial nomination, back when political conventions were choosing the candidates. The state Democratic Party decided to have something called a judicial convention. And the lawyers met the week before the main political convention, and there were no changes in the Supreme Court. Now, the courts were very stable. They always renominated the incumbents. You all would be horrified. That changed when the party primaries were adopted, but Pound came in before we'd seen the full effects of that. The party primaries got really nasty during the Prohibition fight. Is that enough? There are more.
Yes.
This question for Professor Bono. I know you mentioned that partisan elections are a way to confer power because power comes from.
There's a mic coming to you. If you
Thank you. Partisan elections being a good way to confer power to judges, keeping them independent from the politically elected branches, or giving them elections on their own, and it's a good way to confer legitimacy. But why is it the best way to confer power and legitimacy, or at least better than the appointment method?
Yeah, well, so in terms of the power and legitimacy, it's a matter of direct democracy versus indirect, right? So with the appointment method, right, voters choose a governor who then chooses the judges, right? So it's an indirect circuitous route. And so you can think of situations where you would vote for the governor for a bunch of reasons but not judges. Or, hypothetically, let's say there was a presidential election and you really liked what one candidate was going to do with judges, but you found a lot of what else that candidate did not particularly palatable. It puts you in a real dilemma, right? And so that would never happen. But if it did, it puts you in a real, dilemma. And so taking that out, right, restores some independence, to that judiciary. And again, right, I think these are issues on which reasonable people can disagree and come down on different sides of things. I think partisan elections generally have taken, a flogging in recent years as being completely ineffective to do these things. My preference on something like this, that when you're dealing with policy-making offices, those should be done by, by the people, and assuming that the people have enough information and everything else. And as Chief Justice, Phillips said, that for statewide races, like, if you don't know, it's your own fault, right? These are high-spending races. Oftentimes, these races involve more spending than Senate races in the states where they have it. And so, if you're going to change from what you have, it seems to me you need to make sure that what you're getting is at least as good as what you have, if not better. And it's unclear to me if that need is there.
Yes.
Yeah, two quick
Kelly.
questions. One for Professor Fitzpatrick. The chart that didn't make sense to me, and I wonder if you could explain it, is that in partisan elections, there was an ideological skew, which seemed a little odd since it's partisan elections. Other question is, the studies I have seen in the past, at least, maybe 10 years ago, and I don't know if this is still true, showed that partisan elections resulted in judges who worked longer and issued opinions that were less extreme. And I wonder if that's still what the data showed. I know I'd seen that in the past.
On the first question, it's a very good one. Why is there more of a skew in the partisan election states than there is, say, in the political appointment states? And the answer is that in many states that rely on partisan elections, there is an exception for an interim appointment. The interim appointment is not elected. The interim appointment in many states is done by the merit commissions. And so you get a bit of a hybrid in some states between merit commissions and partisan elections. Now, I'm not familiar with any data on working harder or less extreme, but maybe Professor Bonu is, but I am familiar with a paper that says that elected judges write more opinions than judges that are not elected. So that could be what you refer to as working harder, that they process more cases than judges that are not elected. Do you know of any other papers, Professor?
Yeah, no,
Bonu?
that's right. I mean, so so the study was trying to look at judicial quality, and so they find that appointed judges get cited more by other courts outside of that state, but that judges in partisan election states write more opinions, and so basically it's a trade-off. It's really hard to get traction because, one, there are so few states that elect partisan judges, and two, so much of it's a function of caseload and workload. Then you have other variations in terms of if you have short terms of office, right? If you're running for election every 6 years, you're not going to be able to issue as many opinions as if you're running for office every 10 years. I mean, it's just, right? And so all those factors kind of come in. So, I mean, I think the best evidence, looking at all the evidence in totality, the best conclusion is that it's a wash, but it certainly is not. But partisan, if anything, partisan election judges do write more opinions, but the reason for that is unclear.
Eddie, and then there's a mic coming to you.
Professor Fitzpatrick, I think the ideological skew data that you put up there showed political appointments as having the least ideological skew.
Correct.
But what's really interesting to me is the U.S. Supreme Court, which is politically appointed, to me, strikes to have quite a lot of ideological skew, meaning since the New Deal, justices haven't always sided with the appointing president, or over their career, there seems to be a drift, and there seems to be a drift in just one direction. Can you address why your data for state courts isn't showing the same thing when appointments are being used at the highest court?
Well, one thing I might say there is that anytime we deal with small sample sizes, you can get a lot of variation. Right now, the Supreme Court is 5-4. The country is pretty divided, 50-50, so I think it's actually a pretty good reflection of where the country is right now. Historically, it's harder for me to make an assessment, I guess, of whether the Supreme Court was skewed one way or the other compared to the American people. There is a scholar at NYU named Barry Friedman who has a book that's entitled The Will of the People, and his thesis is the Supreme Court basically always follows the election returns. And so if that's true, then I think it is consistent with the notion that political appointment produces less skew than some of these other possibilities. One reason why the federal system could result in more skew is life tenure. Because they serve such long terms, there's a real lag between the views of the judges and the views of the people. You could, basically, the judges might reflect the people's views from 20 years ago as opposed to the people's views of today. So if there is this disparity, that might be my hypothesis on why it would exist.
Right there in the back.
Hi there. My question also is about the ideological skew. And is there an implicit assumption in your work that if we look at that graph with the skews, that we want that graph to be at a zero with a normal distribution of
Yes,
zero?
it is. It's
that
not an implicit assumption, it's an explicit one.
perfect? And so if you get your way with the system you want, is that what you think is going to end up with us having a normal distribution with a zero, and why is that a good thing?
Ideally, everything else being equal, I think that we should have our judges with the same views as the people in their states, because their views drive how the law is interpreted. And I think the people have a right to have the laws interpreted in their states the way they want those laws interpreted. I don't think the legal profession has a right to get the laws interpreted the way the legal profession wants, as opposed to the way the public wants. If anyone has a right to have laws interpreted in their image, it is the public.
And the important thing with that skew graph too, right, is with the partisan elections, the interim appointments, which is a huge deal. Roughly about 1/3 of judges in partisan appointed states, including, I believe, both Justice Brown and Chief Justice Phillips, were initially, Chief Justice Phillips, you were initially elected, correct?
No, initially appointed.
You're initially appointed, right. And so that's a common way, right? Judges leave for other jobs in the federal system, or they retire, or they resign, or whatever else. And so that's when that skew comes in. If you look just at the election results, right, and you didn't have these interim appointments, I suspect you'd be basically spot on, because for the reasons that were discussed earlier.
In 2017, the Texas legislature abolished straight ticket voting for 2020. How do you think that's going to affect judicial elections in Texas?
Well, I can tell you, so when we looked at straight ticket voting, right, we had to focus exclusively on nonpartisan elected states, because you didn't have, there were no partisan states that elected judges that didn't have straight ticket voting. In those nonpartisan states, nonpartisan elected states with straight ticket voting had lower voter participation. And that makes sense, because if you went in and voted straight ticket in a nonpartisan state, you thought you would vote for judge, and then you'd walk out. When I lived in Michigan, I never once voted for the state Supreme Court, because I'd go in, I'd vote straight ticket, and I'd leave. And I'd go back to my office, I'd be like, uh-oh, right? And I know better, right? And so I suspect what you're going to see is you're going to see voter participation drop in judicial elections, so you'll see higher amounts of ballot roll-off. In terms of, is it going to affect election results? I'm highly skeptical. Perhaps at the district court, right, the trial court level, it might. But, I mean, no one had to vote straight ticket before, right? You always could split your ticket if you wanted to. And so if you wanted to vote for your local district court judge who was of a different party than everyone else, that was always an option. I don't know what the percentage was in Texas. I know in Alabama, it's only about 1/4 of people use the straight ticket option.
It's much higher in Texas.
Is it much higher?
Much over half.
Oh, wow.
A big chunk, in excess of 50%, have voted straight ticket in recent years, and that's gone up every year.
Yeah, I think our last analysis, I think it was only about 1/3 of the people voted, picked their way down the ballot. The other 2/3 were straight ticket.
But you're gonna have more roll-off, I think, because with the long ballots you have in Texas, you're gonna have a lot of voter fatigue, particularly as you get down to, right, if you have, I mean, I've seen ballots up with, like, dozens of, I mean, so I think that's that's gonna be a big concern. If you're like one of the last races on the ballot, you're gonna see participation in those races far, far lower than.
Yeah, there should be more data on this because close to half the states had a straight lever 40 or 50 years ago, and now it's down to, I think, 7 states. But they just must not correlate, at least with places with with the elected judges, partisan elected judges. At any rate, I think this first time is going to be very interesting, and it scares me a little bit because when I was running, you could identify where the ticket splitters were, and you go talk to them. That's where we work door to door or sent mail, is in places where half the people split their ticket. Now that's a political malpractice. You're going to go to people who identify with your party and just like try to convince the people that have only voted for Trump in their whole lives to go down the ballot. The Democrats are going to try to be educating their voters that, hey, we've had ads for years, just pull the lever. That's no longer the deal. And so I think the judicial candidates will be their comments will be more partisan than they've ever been before, as they're out there trying to just get their built-in vote to actually vote for them. But, it'll be very interesting for you political scientists and worrisome for us practicing lawyers.
I think it's going to help the billboard industry in the big counties. Right? Sure. Because just having your name out there where somebody sees it on the interstate when they drive to work every day will be more important than it used to be, because when people are picking their way down the ballot, if they try to, just recognizing the name is going to have more value than it used to, I think.
Yeah, it'd be interesting to see. I would also expect, because of that, right, spending will go up, right, particularly in those down ballot races, right, because previously you could just rely on straight ticket, whatever, particularly in your local district or whatever else. Now, if you're worried about people not participating and forgetting you, whatever else, you're gonna have to, right, you might have to raise and spend more money, which would be a perverse side effect, right? If we're concerned about money in politics, then we adopt this reform that might increase it. It'd be interesting to look at.
Well, we weren't able to get to all of your questions, but we're out of time. Let's thank our panelists. I think it went really well.